Welcome to Immigration Quicktake. This is Jessica Eyes with the American Immigration Lawyers Association. On January 3, 2013, the United States Citizenship and Immigration Service published its final rule on provisional unlawful presence waivers for certain immediate family members of U.S. citizens. The rule went into effect and USCIS began accepting applications for provisional unlawful presence waivers on March 4, 2013. However, AILA members across the country have demonstrated concerns that the Provisional Waiver program is not working as we believe the administration had intended. Rather, it is letting down U.S. citizens, spouses, and children who are unintended victims of harsh immigration law. Here to discuss the issue is immigration attorney and AILA member Jason Mills, the current secretary of the AILA Texas chapter and member of the National Benefits Center Committee, joining us through Skype. Jason, first and foremost, can you please give us a rundown on the provisional waiver and what it was intended by its creation?
Well, sure. The provisional waiver is a means to allow those individuals seeking an immigrant visa who are immediate relatives of U.S. citizens and subject only to the ground of inadmissibility found during unlawful presence under 212A9B to allow them to file their waivers in the United States throughout the adjudication of the waiver before they have to depart.
Thanks, Jason. And could you explain to us the nature of the problems being encountered and the repercussions they are having on the families?
Sure. What we're seeing is USCIS has taken a very strict approach in regards to the standard of a reason to believe an admissibility may exist. They are applying this to issue blanket denials without really any meaningful analysis in the process. And therefore, we have seen an erosion in the trust and the confidence in this process overall. But we've seen denials based on someone that has any particular criminal history whatsoever, whether the arrest resulted in a conviction or whether the conviction was a very minor offense that in the waiver analysis would not present any ground of inadmissibility whatsoever. We're also seeing denials based on the use of a false name after an arrest for an entry without inspection. This is clearly not a ground of inadmissibility in most cases. And finally, we're seeing the standard used inappropriately in other contexts as well, such as the permanent bar found in 212A9C without any meaningful analysis, and that's the problem that we're facing.
How can these cases be fixed? What could be done to help resolve these cases, and what should AILA members do when confronted with this situation?
Well, what we're doing is urging USCIS to adopt a standard that's more similar to the approach as handled by the Department of State when they encounter a reason to believe. And that approach really involves, once they find a reasonable suspicion that there might be a ground of inadmissibility, further evidence and analysis is looked at before they make the determination of a reason to believe exists. And USCIS is stopping the analysis at just seeing the scintilla of evidence or the suspicion that something exists and not taking that second step that we think is critical to fix this problem.
Thank you, Jason, for joining us. To AILA members who are watching, remember that if you come across any of these cases, share them on www.aila.org/examples. For the rest of you, please stay tuned for more updates through Immigration Quicktake with the American Immigration Lawyers Association.